Welcome back to Saturday Agenda. 2 weeks after the Supreme Court blocks President Biden's student loan forgiveness plan, the president's announced he's automatically canceling $39 billion in student loan debt for more than 800,000 borrowers. This comes as the Department of Education noted how many students who should have been previously qualified for loan forgiveness at the beginning of Biden's term didn't come through because of historical inaccuracies in the DOE's income-driven repayment program. Now, the administration claims that many borrowers who should have moved closer to forgiveness were not accounted for. I want to welcome in our legal panel. We have distinguished professor at Touro University, Thane Rosenbaum, along with the attorney and U.S. Senate candidate from Nevada, Rhonda Kennedy. Thane, Rhonda, great to have you here. Thane, I want to kick this off with you. So the president is basically circumventing the Supreme Court's decision and forgiving a lot of money from these borrowers. How?
So, Kilmeny, the Supreme Court says $440 billion is a lot of money for the executive branch to cancel. Congress has the power of appropriations in the purse, and this is what's called part of the major questions doctrine. When it comes to matters of extreme political or economic consequences, Congress has to make the decision. So the Supreme Court said the Department of Education can't wipe out $400 billion, and it can't use a 9/11 statute for emergency purposes post 9/11 that was really there to help service persons serving in Iraq and Afghanistan from having to default on their loans, that you can't use that provision as a way to bootstrap the pandemic and say, well, we're just going to use the 9/11 statute as an emergency statute that applies to the pandemic. Supreme Court said you can't do either of those two things. So what President Biden simply says, all right, well, if it's not 440 billion, what if it was just 40 billion? What if it was only 10% of it? Does that hit the major questions doctrine? Right, is maybe that's a lower number. And he's saying it doesn't involve as many people. And I'm not using a different statute. I'm using a regular law through the Department of Education. We made technical, inaccurate mathematical mistakes. Some of these people should have already had their loans forgiven. Once you pay for 24 years, if you're a low-income person, we just forgive the rest. And we made mistakes. So we're really not using another statute. We're doing it internally through the Department of Education, and we're doing it to correct the mathematical inaccuracies of our own people. It looks like a circumvention. It is a circumvention, but it directly goes to address what the Supreme Court was worried about. It was worried about huge amounts of money and using the wrong statute. Yeah. That's what they're addressing here.
Rhonda, how do you think this will be challenged?
Well, it's, this is the Higher Education Act of 1965 is what Joe Biden is trying to bootstrap this new thing to. And I've been following this very closely. And if you see, the majority of the people who are upset and protesting look like millennials. And however, under the Higher Education Act of 1965, you have to make between 240 or 300 payments. And that puts you about 20 to 25 years. Some of these protesters aren't even 25. So one thing is Joe Biden is just, again, just misleading the people. It's political pandering, it's predictable, and it's just plain pathetic. It's not going to survive the Supreme Court. Joe Biden had 36 years in the Senate, in the U.S. Senate, which is a legislative branch, a branch of government that actually had the power and authority to be able to do something about student loan debt. He had 8 years under President Obama. He did nothing then. This is just another political ploy. He did this in 2022 when it was a crucial election for the House and the Senate. And now he's doing this in 2024 when he's up for re-election, just to grab votes for a certain demographic that they won't even get any benefit from it.
Panel, switching gears, and we're unfortunately almost out of time, but I want to hit this really quick. Thane, former President Trump's defense team was asking for his classified documents case to be postponed until after the 2024 election. But the special counsel, Jack Smith, and his team of prosecutors, they're pushing back, saying that there's no basis in law or fact for granting the motion to postpone the trial. They also called the defense's suggestion that the Presidential Records Act offers them protection is, quote, borderline frivolous. Really quickly, Thane, we've got about 30 seconds. I want you to weigh in.
So, Kilmeny, look, what they're saying, the president's lawyers are saying, this presidential campaign cannot be divorced from the prosecution. You can't do both. You have a presidential campaign that's being initiated by the Justice Department within the executive branch. Joe Biden is running against Donald Trump. Clearly, this is going, the appearance of politicizing the Justice Department is clear. You can't divorce the campaign from the prosecution. It has highly national security implications. You've got the weaponization of the Department of Justice. You have a jury selection problem. It's going to be very difficult to do that. And no, I have said on your show many times, the Presidential Records Act is a legitimate argument that the president is allowed to make, and I frankly think could prevail on it.
All right. It will definitely feature into his defense. Thane Rosenbaum, Rhonda Kennedy, thanks for being here.